Hello everyone, this is Anne with IP Note. Today our trusted partner Carlos has joined me to discuss IP matters in Mexico. Hello Carlos, thanks for joining.
Thank you, Anne. It's good to be here.
Carlos, your firm has quite impressive experience of over 30 years in IP. Could you kindly give us a brief overview of the current landscape of IP law in Mexico?
Well, it's actually 42 years.
Oh,
Not,
really?
yes, I mean, just for the record. Well, I think Mexico is facing interesting times as far as intellectual property is concerned. We are having our first approaches with a new law that was enacted in November 2020. It's already almost 4 years. But the significant changes affected litigation, enforcement, and prosecution of patents mostly. There is a little bit of on trademarks too. So it is a bit too early to conclude if the changes in the law have been favorable or not. The Mexican Patent and Trademark Office has also been facing quite some challenges budgetary, in terms of personnel, and a few adjustments on how things are viewed uh, in the face of the NAFTA treaty with the US and Canada, and also with the free trade agreement that we currently have with Europe and a couple of others, but those are perhaps the most significant ones. So for the first time, we have statutory provisions that allow for the extension of term of patents. We didn't have that before, although there was one or two precedents at court that allowed for adjustments on the term of the patent. Now we do have statutory guidance as to how and when it will be possible to extend patent term. We also have, for the first time, in the law, in the IP law, legal provisions that rule or guide the collecting of damages as a result of patent or trademark infringement. Again, this a rather new addition to the law, which is being received by the bar with a little bit of a reluctance because all the changes in other laws are needed to fully implement the changes in the IP law. But nevertheless, it has opened a new route for patent and trademark holders who wish to enforce more aggressively in terms not only to prevent infringement, but also to collect damages. And damages may be very high indeed. Under the law, it's at least 40% of the value, the gross value of the infringing goods, which can
Wow.
be quite significant. Yes. We haven't tried it at court just as yet because these new provisions are rather new. But their being in the law calls for much more preparation and much more be mindful of what will you be doing in Mexico because there may be consequences. Not only you stopping from infringing a trademark of a patent, but also there can be significant financial consequences that may lead even to bankruptcy. There is a current dispute, so far not in illegal proceedings, but in the bar, whether these provisions are really in line with the Constitution or not, because they may be seen excessive. I do not know. It's a matter that will need to be further decided, perhaps at the Supreme Court of Mexico, because it's a difficult issue. In Mexico, we do not have statutory provisions governing damages other than actual damages. In the United States and in some other jurisdictions, there are punitive damages. And the law in Mexico is silent about those. So could you view 40% on the gross volume of sales as punitive or not. So there are many, many things still to be defined, and we will not see them defined, but in the courts. And in my view, it'll still take a few years before we have a final decision. Uh, but as long as the landscape, the current landscape is concerned, we need to take into consideration that those laws are now in effect, and anybody can enforce them, can try to enforce them at least. So patents, on the one hand, with this possibility to extend the term is very relevant. Damages are also a very relevant change in the law. And there are a few other, maybe, I wouldn't like to use the word minor, but at least more frequently used on trademarks. We have now the obligation, as we did before, but now it's more clear to prove the use of a trademark before being able to renew. And also on the third anniversary of a registration. If you don't comply with the filing of a declaration of use, the registration will be expunged from the registry and will be deemed abandoned. But the manner in which the declaration is to be filed entails some detail. Under the law, the registrant is to list specifically the goods or services upon which the mark has been used in Mexico, not abroad. And if you try to claim in the declaration, let's say the class heading or a very large description of goods or services, you may incur in a violation to the law. And these declarations are filed under oath. So even the attorney filing or signing the declarations may be liable for some sort of a administrative offense as declaring something under oath, which is not really support on facts. So the filing of a declaration of use with accurate and precise information is a must. Now, I don't think people can overlook that. We have to be mindful of the details surrounding this declaration of use. The issue is also a little bit complicated when it comes to filing declarations of use for Mexican designations of international registrations, because again, the law is not very clear as to when are you to file these declarations of use. Let us assume for a moment that there is an international registration which is due for renewal in Geneva this month, today. The Mexican designation will need to file a complementary declaration of use, but the law is not clear as to when will this declaration of use needs to be filed. And we have explored the different legal provisions governing the Madrid Agreement and the protocol, the Madrid Protocol, and reached the conclusion that the safest way would be to file this declaration of use within the 3 months following the publication of the renewal notice by WIPO. That is our position, our firm's position, yet it is not fully supported on specific legal provisions. We adopted that position simply to be on the safest side, to avoid any kind of risk for filing a declaration late and creating a problem with the Mexican designation. But then we have to be very careful. Registrants owning international registrations hardly ever retain counsel in Mexico to monitor the registration, because apparently there shouldn't be a need for that. But the Mexican Trademark Office will not issue an advance notice of the obligation to file a declaration of use. So registrants in other countries, in Europe, for example, might not even be aware of the fact that they need to file a declaration of use in support of a renewal. They may think that by renewing the international registration, everything falls within the same renewal notice, which is not the case, at least not in Mexico. If you don't support a renewal application of an international registration with a Mexican declaration, the Mexican designation will expire. So that's another thing that it's maybe not very, very clear in the law, but we have to be very mindful as to the effects of having a Mexican designation based upon an international one. Going back a little bit on patents, there is also a huge debate created by a prohibition in the new law against divisional applications from divisional applications. Up until 2020, November, it was possible to file a sequence of many applications, of divisional applications from one mother one. We have cases in which we have maybe 10 or 8 or 7 divisional applications, and there was never a problem. Right now, the law says quite clearly that it is not permitted to have a divisional application from a divisional. There is only apparently the possibility of one divisional application from a mother one. There are ways in which you may try to extend protection, but it's becoming much more harder than what it used to be before. You have either to convince the examiner that there is reason for a second or third or fourth divisional application based upon the unity of invention principle, which remains effective. But again, the patent office is not very in favor of having more than one divisional. We have now cases in court fighting the refusal of the patent office to accept a second, third, or fourth divisional application. Unfortunately, we are yet to have final decisions on these appeals that we have filed against the denial of accepting a new application as a divisional. We are hopeful that we'll have good results, but you never know. So we are still ahead a few years ahead a final decision. But that's another thing that anybody willing to file an application for a patent in Mexico needs to be aware of. It is not going to be as easy to file divisional applications, so it's best perhaps to give a wide review of the case, of the description, and if you find that there are more than one invention, file different divisionals from the beginning and not waiting until the examiner requests, because the examiner may not request more than one. I think that would sum up some of the most relevant changes in the law, which have caused some discomfort to some people, and which have
Yeah.
in any way create a very interesting time for us as lawyers dealing with IP cases.
Yeah,
So,
I have faced the declaration of use in Mexico, and I've just noticed that a lot of applicants are confused by this declaration because they do not understand when, why, and how to use it, to apply, to submit it, etc. So
yes,
that's an interesting topic, really.
yes, we have prepared a little article addressing the particular issue that we may send over to you.
Sure, sure.
Your clients may be willing to read it and learn more a little bit about it, and we will of course be happy to explain any doubts that may come up.
Sure, that's great. And regarding the issues, uh, could you kindly share what are the most common IP issues that businesses usually face in Mexico, in your opinion?
Well, there are quite some. Importation of illegal goods through customs is quite an issue. Mexico has miles and miles of seashores and border, mostly in the north, with the US. So we are a natural target for the arrival of illegal merchandise. Thousands, if not millions, of products that come from Asia through Mexico end up either in the US or in South America. And of course, the Mexican market is flooded also with illegal products. So that's quite an issue. It's difficult to detect illegal imports of goods. Trademarks, I'm referring only to trademarks. Patents, it's a totally different story. But for trademarks, the importation of illegal goods from other sources is quite an issue. And there are ways to monitor custom offices to see if illegal imports are being detected, there is a way to register a trademark with customs, which will compel the officers at the different customs offices to take a look. Although the process is not perfect by far, they are effective in a way in detecting some of the illegal import operations with legal goods, but it is not by far enough. So a suggestion is, of course, to register the mark with customs, but also to keep monitoring the different markets uh, on the borders, the US, South America, or Central America, and also internal markets. Not all goods are sold in formal type of stores or chain of stores. We have plenty of street markets throughout the country. And it's once the goods come in and are distributed among maybe 100 street markets, it's almost impossible to be successful in seizing these products from the streets. So I think it is always worth the while to make a good monitoring of customs in an effort to detect who the illegal importers are, where do the goods come from. People may think China, of course, China, but that's not the only country. Vietnam, North Korea, sometimes Thailand, uh, many other countries also are the origin of illegal goods, and they all flood us. We have from everywhere. As of recent, from the Middle East, we have detected some goods coming from Dubai, uh, which surprised me. Uh,
Yeah, this is
yeah,
a surprise.
yes, they are so organized and so well established that it surprised me to see people. I mean, goods, illegal goods coming from those countries. The north of Africa is also known for exporting into Mexico illegal goods, mostly women purses, glasses, as of recent. Uh, it's a major problem. I think that's one of the things that if you are selling in Mexico, you should be aware of, and measures should be taken to prevent to the extent possible. Another thing is perhaps on trademarks, again, how to use it correctly. The law is very clear in saying that if you change the mark as registered, you may cause the registration to expire for not illegal use, but an insufficient type of use. And this is a case very, very often with registrations with a design or with colors, when these colors are claimed. If you claim the color green and yellow, and then eventually you sell in blue and yellow, that may be a problem. So you have to be very, very careful of how you register and then how you use. Discrepancies between what was registered and what is actually being used may cause problems. Not only with the trademark office when filing a declaration of use, that may be a not very frequently objected. But if you face a competitor, the competitor will have the basis to try to challenge the registration simply because you don't use it as you registered it. If you change the font of a word mark, if you amend in a way a design with or without a color, those issues are important now. They were not as important before. Now the law is much more strict on ensuring that you use exactly what you registered. The date of first use is also to have in mind. Trademark applications in Mexico have a little space where you are supposed to insert whether you have used the mark or not, and if so, when. Of course, this information concerns Mexico exclusively. It doesn't mean that you used it in Europe or in the US or in Japan, but in Mexico. And when I say any, I mean it, any mistake, even by a day or two, may cause the registration to be eligible for cancellation. We not long ago had a case in which the applicant inserted a date of first use. And then the date of first use was challenged by a third party. And we were provided with evidence of use of the mark earlier than the declared date of first use. And we had a very, very difficult time prevailing there because the trademark office said the law says inaccurate. And it is inaccurate whether you commence the use before or after the date established in the application. So
Wow.
nowadays, yes, it's a bit strict, and I couldn't quite understand the reasoning behind that. What if you claim today as a date of first use, but I started using it a week before? In my view, based upon the old law, there wouldn't have been a problem because at least you started using it on a given date, perhaps even a little bit earlier. But nowadays, a little bit earlier means inaccuracy, and inaccuracy leads to potential cancellation. So you have to be very careful. Have you used it in Mexico or not? The applicant has used it in Mexico or not? Not through a distributor, not through a licensee, because the licensee is not registered or recorded with the trademark office when you file the application. So it's an issue we spend a lot of time with our clients to decide if we are going to claim a date of first use or not. Sometimes it is best to rely upon the use in a foreign country. Like if the company is a UK company, most likely they started using the mark before in the UK than when they started using it in Mexico. So sometimes it's best to leave blank the date of first use and rely upon, if need be, the date of first use of the home country of the registrant. I would say those are the most relevant things that you have to take into consideration.
Okay, that's interesting. And with these challenges in mind, I'm wondering, have there any recent changes or let's say updates in the Mexican law that businesses should be aware of?
No, not yet. Other than those that I've told you about so far, no. But we should be having a new regulation to the IP law soon, sometime soon. I don't know. And these regulations to the law, which have been pending since almost 3 years ago, are expected to have new things that we will need to take into consideration. But we need to wait until these regulations are enacted and become effective before we are able to say anything. I've seen drafts of the regulations, but those are not final. They are still subject to reviews and amendments. We are having in Mexico a change of presidency the next month, and the new government may or may not decide to enter new changes in these regulations. And while I have been aware of some of them, some drafts of the regulations, uh, neither has been confirmed. And I think it'll be irresponsible from me to say anything about it.
Sure,
I
sure.
don't know.
We shall see.
Yes, we shall see. I think we have to be patient. But for the time being, at least take into consideration what I've just commented with you so
Uh,
far.
we have discussed some issues that businesses usually face in Mexico. And are there any unique challenges that foreign businesses face in Mexico if they are operating there or registering IP there?
No, I don't think so. I think Mexico is a rather efficient country when it comes to issuing registrations, for example. Even patents. I think we have a good set of examiners in Mexico, and uh, except for perhaps some very, very complicated cases, the average length of time for a patent is still 3 years, which is fairly average
Yeah.
comparing with other countries. A registration in Mexico is granted in about 6 months, unless there is an opposition or unless there are objections. But if the application doesn't face either oppositions or objections, you may obtain a registration in about 6 months on average,
That's pretty
6 or 7 months,
that's
which is
pretty
pretty
fast.
quick.
Yeah.
Yes, it's very quick. What I always advise clients, uh, even before filing anything, do a search. Do conduct a search. I know that it may take some time. I know that it adds to the costs, of course, because you need more work, but it always pays off. It always pays off to become aware of potential complications along the way. So do conduct searches, even if you need to conduct a few of them in different classes. There are some classes which are a little bit complicated, like class 41 for entertainment services. Do check also other classes, perhaps 25 for clothing. They go together very often. Uh, Class 9 too for glasses, for example. On food, if you sell potato chips, that's class 30, if I recall correctly. Do apply for class or search at least class 32 because raw potatoes are included there and there may be a conflict. So the preparation of the application is not limited to the drafting of the application, but also entails to be careful on the searching. Examiners at the Mexican Trademark Office do conduct cross searches for crossing classes. They are not limited to the class sought by the applicant. Class 35 can really be a pain. Uh, if you claim commercialization of, let's say, lipsticks, uh, they will check class 3 to see if there is something that may conflict with the class 35 application. So a good search is always recommended, and that may save a lot of time and a lot of money to clients. So
Yeah, a lot of money, first of all, because
yes,
applications are much, much expensive than conducting.
yes. A search is relatively non-expensive. It can be done rather quickly. And then investigations with the direct companies holding registrations that may or may not be conflicting, it's also best done before filing, before we commit to an application, before we face a deadline to respond to an objection. Deadlines are a little bit narrow in Mexico. It's only 4 months to respond to an objection. 2 months first, and then you can extend 2 more months. But that's it. If you need to cancel a cited registration, it needs to be done within these 4 months. And sometimes it is not enough. If you want to challenge a registration based upon use in another country, you need a ton of evidence of use in, let's say, Germany. And you take a few weeks to report, and then the client takes a few weeks to consider, and then perhaps you are given instructions when it's less than a month before the deadline. And to prepare a case in less than a month is very difficult. Yes,
I
so
can
do conduct a
imagine.
search. Yes, do conduct a search. In terms of patents, don't go on the last possible day. Mexico is a PCT 30-month country. That's it. It used to be the possibility to extend to 31 months. Not anymore. That's gone. I don't think it'll be back ever. So when you provide instructions, try to be as more in advance as possible to the final deadline. Another thing, and this may be minor, but it has caused some complications. DocuSign is not permitted here.
Oh, really?
Yeah. If you are signing a power of attorney, it needs to be wet ink signature. We do not need the original, though. You may scan the power of attorney, send it over to us, and that'll do. But it cannot be using DocuSign or similar, any other alternative for electronic signing. The law needs to be amended to accept electronic signing. So it has to be wet ink. Sometimes if you need to enforce something, the power of attorney needs to be notarized and legalized by apostille. And that kind of also creates some delays, at least. There are some countries in which the apostille is very easy. Europe is very easy. The US sometimes is very easy. But for example, in China, takes time, takes time. And then a document apostilled in China will need to be translated into Spanish, which also is, or maybe a bit demanding. There are not too many Chinese translations in Mexico. So please don't send instructions too close to the deadline. Sometimes we need a bit more time to prepare these kind of documents, even an assignment document or a power of attorney. Sometimes the person who can sign is on holidays or is abroad on a trip, and we need the ink signature. So these are very minor things, but everyday hurdles on a number of cases every day. So try to be prepared as soon as possible.
Yeah, I think there are two rules. Firstly, is conduct is to conduct a search always for trademarks and patents, and secondly, act as fast as you can so
Yes.
that there are no delays.
Yes. In terms of searches, we always conduct an exact search, even without instructions from the client, on the day that we file. And we do that complimentary. We never charge for that. If we find something identical, we will hold on the filing and let the client know. But our search, which is complementary and which is done always, regardless of instructions from the client or not, is not very thorough. We only look at the identical trademarks, only identical, for the identical class, of course. And sometimes that is not enough. Most of the time, it is not enough. We feel that we have to do that at least, without instructions. We do that all the time, always. It's within our internal policy. And it helps. We do find eventually registered marks for the exact identical mark. It's not unusual. And then at least the client knows that we will be facing something up the road. But nevertheless, that does not discourage conducting a thorough search, sometimes even a common law search. We do have access to several internet engines that allow us to detect goods which are not registered, perhaps, but which are being used in the country. Our country is pretty large. From the Caribbean to the south of California is 5,000 miles. So it's huge territory. Anything can happen anywhere. So do conduct full search.
Yeah, that's great. And lastly, for today, since we're living in the digital age, I'm wondering, how is Mexico addressing the challenges of protecting IP, especially with the rise of online piracy?
Well, that's a very, very good question. I think Mexico has created a platform here that allow us to best serve the interest of clients when it comes to the digital world through intellectual property and through copyrights. On many occasions, we suggest clients to register copyrights, not only for music or books or paintings, which are, of course, the nature, the natural field of copyrights, but television ads, for example, are subject of protection. Uh, there are ways to protect under the copyright statute clients lists, distribution lists. Uh, Mexico has followed the criteria of the US when it comes to the digital world, uh, but then do cover classes, for example, 41 for some digital content. And we represent a few companies in the clothing industry, and they have their own digital version of their wares. And sometimes a class 25 would be enough. Not always. Sometimes you have to be a little bit more creative in terms of what classes are you going to protect if your goods are not sold on a store but on the web. So we have to be mindful. There are ways. I think Mexico is prepared, yet it's a case by case basis thing. Every company has different potential complications. So our best knowledge of the company allows us to provide or to offer better solutions ahead of the problem. But we are mindful of it. We support ourselves on the digital world by the copyright law, not only the IP law. copyrights are very important.
Yes, yes. Thank you very much, Carlos, for your
Thank
time
you.
today. This was incredibly informative.
Thank you.